And you need to calm down. You are in a courtroom.
Yeah, I'm kind of upset.
Well, here's the thing, Mr. Kilpatrick. I'm sure a lot of people are upset.
There's no curfew, nothing like that. Like I don't want to get in trouble. I hate getting in trouble. I don't get in trouble. I just.
Is that your case, or is there something else that was going on in your life? Because you're looking at 20 years in prison. If you're currently alive, let's start at that as a base of happiness, okay? All right, so what is happening with his case? I see that there was supposed to be a viewing of a video.
Right, so back in April, there was a disclosure that there was a surveillance video, which is a very key and essential material piece of evidence that Mr. Taylor would like to view and discuss.
All right, has it been allowed to view it?
Well, not yet. I mean, I've asked the DAs a few times to see when it was ready to be cut in a DVD.
All right,
CD,
let's sign out.
but they have new information.
Yes.
Judge, I just spoke to the trooper that's on the case, and she's going to work on getting that to our office this week, whether that's on a disc or if they can submit it via their eyes.
Okay, so
We're barely seconds in, and the judge already has to remind someone to calm down. Courtroom rule number 1, your emotions may be valid, but the judge still runs the room.
you all should have it in your office this week.
That's my understanding, yes, Judge.
All right, so Mr. Taylor, this is what we're going to do. We're going to recall your case for next week. The video will be brought down and you will be allowed to view the video.
I appreciate you, Your Honor. And Your Honor, one more thing I would like to mention also. Last month, I was upstairs on the 7th floor on Wednesday, April 13th, 2022. Of my attorney, he happened to tell me because I was insisting, and I see the video. They said the DA has it. That's what my attorney, James Mayret said. The attorney has it. The attorney, the DA has it. So pardon me on that. The DA already has it, and so it's been 5.5 months, and no surveillance have been recovered.
Mr. Taylor, let me explain something to you. So,
and this
the first, well, just 1 second. I understand this. You're saying it's to prove your innocence, but let me explain something to you. The first time that this case came to this court, because I write everything down here. And the first time it came was on April 13th, and it was recalled for April 14th. On April 14th, that's when I was informed that there was a video, maybe, or surveillance video, and that the state was going to do their best to have that video for May 16th, because I had it reset for today, May 16th. And what I have is recall May 16th, 2022, defense attorney to view video with client. All right, so the state is telling me they don't have the video yet. What they're telling me is they will have the video this week. I don't want to call you back here tomorrow and then the next day and the next day, and for them to tell me, oh, we have the video Friday, because the state is dependent on somebody else, a different agency, to get them the video. They're telling me that they will have the video this week. So I'm going to recall your case for next week, and the state will have the video, and you will get a chance to watch the video. And if the state gets the video before the date.
And there it is, the reality check. Whenever a judge drops the actual possible sentence out loud, that's their way of saying, take this seriously right now.
That I'm giving you, they will make sure that they give it to Mr. Myrick, and he can watch it with you at the jail. If not, you can watch it here in the courtroom, okay?
I appreciate you, Your Honor, and Your Honor, and pardon me also, Your Honor. And by the way, what should be in the videos does not correspond to these charges and what's in the
Okay, so
indictment.
let's do this, Mr. Taylor. First, let's get the video so that you and your client can watch it together, okay?
And I appreciate you. And one thing I would like to mention on my behalf, because it seems like I'm not getting an adequate, defense, from my lawyer. I just want to mention one thing for what.
Let me just give you a timeout right there. So this is one thing that I require. I require that everyone treats everyone with respect, right? So let's take this one step at a time. The first thing is to get the video so that you can see it. So, Ms. Ferguson, can I have a reset date for next week for Mr. Taylor? And if we could set it in the afternoon, so that in case the video is given to the state on a Friday, he'll be able to come in and watch it that afternoon, and we'll have a free space for him to watch the video.
Oh,
Do
yeah.
you want to do like Zoom or in person? I can do Thursday afternoon if they would like to.
All right, so we can do it by Zoom, and that way you'll be able to watch the video by Zoom. Yes, Mr. Meyer?
Okay, and that would be available on the share file?
Yes.
Okay, pause. Anytime a case hinges on surveillance footage, the entire rhythm of the courtroom changes. Evidence isn't just evidence, it's leverage. And everyone in this room knows it.
The video, okay. So,
All right, so what we'll do is we're gonna recall this on May 26th. Okay, so that's next week. All right,
Yes.
right.
And Your Honor, I might also address one thing. You know, I do expect the best legal representation, and at the same time, I know this incident was like it's at least 165 days ago. You know, and by then, I know by then they should have some type of production or video of something, because when it's something outbreaks on the news, an incident, it's automatic production to the media. So I don't understand why there's no kind of production of course already. It's part of the multimedia system.
well, I will tell you that sometimes it depends on who the media is. You know, when I was growing up, you know, when you would find out what was going on, 60 minutes. Yeah, sometimes it takes some investigation, but we're gonna bring you back on May 26th by Zoom, and they will have a chance, they will have the video, you will get a chance to see the video, okay? And if the state has the video before then, they have Mr. Meyer's number, and they will call Mr. Meyer and say, we have a video, and if we can get you in before May 26th, we will do that as well, okay? Oh, thank you so much. You have a great rest of your day, okay?
You have to go bless money to you.
Oh, thank you. You have a blessed day. All right, so kill.
This is a classic courtroom bottleneck. The judge is stuck waiting on another agency, the defense is stuck waiting on the state, and the defendant is stuck in limbo. Justice moves, just not always fast.
12th, your attorney is not here. And did you hire your own attorney?
You got hired an attorney?
Yes, because I see the notes in here that Judge Angelini stated that he was not going to appoint you new counsel. You would have to hire an attorney. So did you do that?
I didn't hire an attorney. At the same time, I was wondering, like, since I can't hire one, that they're appointed for my constitutional rights.
I'm sorry, what?
Maybe if I can hire one, which I've been, we talked to the family, see if they could, maybe appoint me another attorney.
Now, they're not going to appoint you another attorney.
Because I'll be honest with you, of course, when I say I don't know what's going on, the defense ain't been, you know, informed properly, notified properly, definitely about the discovery, untruthful about the discovery, and definitely the alleged victim statements. It has switched over 2 times from my appointed counsel, so it's like an antagonistic
All right, so
relationship between me and my.
all right, so here's the thing. Sometimes, and I'm not saying this is your situation. I've been a defense attorney and I've been a prosecutor. I'm not saying this is your situation. I know that sometimes people feel as though they're not getting a day-to-day update. And sometimes they want to file your own motions, right? So let me explain to you. The attorney is responsible for filing motions. And let me explain to the other thing. The state is required to give discovery to your counsel. You understand? All right, so we're going to come back on July 12th.
And the honor, excuse me, I want to actually have been asked me about what kind of discovery have they got from the FS system. I definitely discovered from the, you know, when I was in the DPS, the video, like first he said that quote unquote, this was.
Okay, so here's the thing. I don't want you to talk about your case
Oh,
to do
about my
without your
case.
attorney being present.
Oh, okay.
So this is what we're gonna do. Ms. Ferguson, can you make a note for Judge Angelini that who is it? Mr. Meyer is to sit in court with Mr. Taylor and go over all the discovery with him.
And by the way, also, Your Honor, another thing too, I've been asking also to file different motion, like, I had to file my own, like, I've been telling them, like, since of, like, Wednesday of March 23rd to file some motion that's in my hand. Once and command them, if you haven't filed them, and I told them,
All right, let me see.
Wednesday, March 23rd of 2022.
All right, so here's the thing, Mr. Taylor.
And he didn't respond and file.
Mr. Taylor,
So I had.
Mr. Taylor, when you have an attorney, that attorney will file motions. So if there's something that needs to be heard, then your attorney will let the court know. Now, sometimes people will file motions and they're filing motions that their attorney is, maybe their attorney doesn't think those are the proper motions to be filed. But we're gonna bring you back on July 12th. And on July 12th, your attorney will go over everything with you. All right?
And by the way, what about these motions in my hand? These are the ones I've been commanding to file for like at least 2 months.
No, you'll have to take that up with your attorney, okay?
And no one has filed any.
Okay,
Okay, you talk to your attorney. All right.
all right. Well, you'll have to talk to your attorney, okay?
You said July the 12th is. when
July
I go back.
12th, yes.
You know, I just pray that I'm getting the right, legal representation, because I feel defenseless right now. And I feel the way the justice is kind of unequal and unfair.
Okay,
I'm not receiving a fair trial, and I'm definitely going to be honest with you.
okay, all right, thank you. So they're gonna take you back now, okay? A couple of cases are closed.
I think, Your Honor, it was re-indicted.
Okay, so it's 2022, 21, 21, and 21, 22. So those were dismissed to be re-indicted?
Yes, Your Honor. That's fine.
All right. So where are we on 2022 CR 6824?
So, Your Honor, I did speak to the complainant yesterday. She did notify me. We had been missing surveillance video. Whenever I spoke with her, she said that she possessed the surveillance video. She got it to me yesterday afternoon. I've just uploaded it to eDiscovery this morning and notified defense. She also notified me that she had written a statement to UCPD and to her superiors at DPS. She provided that to me as well. And then I think there was a DMV document that Mr. Taylor filled out that she had in her possession that she did forward to me as well.
All right, Ms. Ferguson, can I have a 30-day reset on Kilpatrick for discovery, please? All right, we're going to come back on September 27th to make sure that everybody has everything. All right, Ms. Ferguson, we'll give you a reset date.
Excuse me,
Yes.
I'm just having a problem with this pretrial.
I can't hear you.
I'm having an issue with the pretrial. When I leave this courtroom, I'm going to see the pretrial officer.
All right, you'll need to talk to your attorney about that.
Yeah, it was a big issue, when I was at work,
I understand what you're saying. You need to speak with your attorney about that, okay? Yes, talk to your attorney. Brenda, do you see what other page he's on?
Yeah, he's on 9 and
I'm gonna get the
12.
All right, thank you. All right, so I'm out of rubber bands and the rubber band popped on this one. All right, Christopher Beltran. And Mr. Kilpatrick, you can leave your items there. No one will touch them. All right, so where are we with regards to trial? I know that Impact Court doesn't have any more jurors available. So what is happening with Mr. Kilpatrick's case?
Mr. Kilpatrick would still like to invoke the jury trial. I was talking whether he would consider a bench trial, but he still insists on having a jury trial, so he's not going to waive that.
All right, Ms. Ferguson, can I get a jury trial as soon as possible?
Oh, yeah, I think yes.
may I also ask too, I know it was a motion that's going to be filed, but it show all the tangible and all the evidence that's against
Your
it.
attorney has already received all of the discovery. So if you want your attorney to sit with you in the courtroom and go over the state's file, you're more than welcome to do that.
I want to definitely do all state files, too, the victim impact court, which I don't understand, one thing I definitely will say, for sure, before the court, with due respect.
Watch the judge here. This is where she shifts from legal to parental tone. The "let me explain something to you" energy is unmatched.
Since the state.
Okay, let me just explain something. Let me stop you right there. And I want you to internalize what I'm about to say to you, okay? When people come before me, or even if people are just having conversations, when people say, "in all honesty," you know what's coming after that? Something that's not honest.
Oh, no,
When people say, well, wait a minute.
Oh, yes.
When people say "with all due respect," guess what's coming after that? Something that's not respectful. And people try to soften the blow by saying, "in all due respect." For example, "in all due respect, I don't like for attorneys not to wear a tie." Now see how that softens the blow? But I'm still giving them a lack of respect.
That's another example.
And here's the thing, in all honesty, it's raining outside. So that's not true.
Yeah,
So here's the thing. This is where we are. You're going to get your jury trial date. Your jury trial date is going to be November 15th. And we will see you then. You will get a reset form for November 15th.
By the way, I know this is a quick reset form. I mean, one thing I do want to know, like for instance, I want to ask, I know this victim, whatever it's supposed to be a victim impact court.
It is not a victim impact court. It is called an impact court. And guess what? We have use of that court this week. So that's why you were sent there, so that we could have jury trials up here and there could be jury trials going on down there.
Yes. Also, I want to ask my attorney to also recover the property that I was arrested with, because Burke County said it doesn't have the property I arrested with in the state trooper. So I need to see the property I arrested with. They won't come up on my property, or should I send a proper way to submit my property? Because I've been going through an economic burden since this arrest to today, dealing with Burke County, and definitely stern and constrained conditions with this monitoring will make it more difficult for me, and I have to work.
Well, let me explain to you why you're on the monitor. Okay. You have a case from 2022 CR 6824. That's an assault on a public servant. I don't take it as true, but that's what it is. 2022 CR 2121, assault on a public servant. 2022 CR 2122, retaliation. That's why you're on bond. And that's why, that is why you have the GPS. So your court date is November 15th, and you need to be ready for jury trial. Is there anything else?
Also, I will just speak on my defense, at the jury trial.
This is pure judicial comedy gold. Judges can't roast people. But this is basically the courtroom version of a TED Talk on passive-aggressive phrasing.
You may do whatever you choose to do at your jury trial. I would tell you, you may want to confer with your attorney before you do whatever you want to do at your jury trial. But your jury trial is going to be November 15th at 9 a.m. You understand? Any other questions?
The main question I would ask them just which I asked my attorney, I wish it was a way I could make a request to submit my property to me, and this was some important property, and I definitely need that.
All right, so once your attorney files a motion for release of property or confer with the state over whatever property you have, then
link with my arrest.
Just a moment. So here's the thing. The court will hear whatever motions your attorney filed. Now, if it's something that is and somehow related to the offense, the state is probably not going to want to hand it over, but your counsel is more than able, and the court will allow him to confer with the state on that. Now, the other issue, you said you would like to go over the state's file with your attorney?
Yes.
All right, Mr. Myrick, have you sat down with your client and reviewed the state's file with him?
We have not had an occasion where he came by my office to review the full array of evidence.
Okay, when do you want him to come by your office?
I would like him to come by my office Friday afternoon.
All right.
From 1 to 5, I will be open. He can walk in.
All right, so you go back to your attorney's office on Friday from 1 to 5, and your attorney will go over the entire state's file with you.
Okay, I'll make it. And also, I want to add something.
Do you know where your attorney's office is located?
Put my address on the reset form.
Yeah, so,
And also on the reset form, if you could give him something and know what time you expect him at your office.
and,
Sure.
one more thing, Leona, I definitely have a job, a taxpaying citizen, so that's what makes it even hard. These 2 consecutive days I can show up in this courtroom,
Mhm.
and I'm paying, pretty much have to pay my rent.
No, I understand.
In order to maintain my residency, so, this here, I'm gonna be so honest with you, this here which is gonna have to be explained at jury.
You're trying to soften the blow for me.
No, I ain't softening. I'm just telling it straight up. It's
Mhm.
straight up ears, untrue statements, untrue stories.
Okay, so that's something you present with the to a jury.
I'm not gonna soften the blow by beyond.
No, stop. That is what you submit to a jury. I'm not here to hear your jury trial because you're not doing a bench trial.
This is the moment the stakes finally land. Assault on a public servant is not a light charge, and the judge is making sure he understands why the system has him locked down tight.
So you need to sign your reset form. All right, who's here on Placido Jacques? All right, what are we here for?
2 motions.
Yes, what are the 2 motions?
There's a motion.
Just in the middle. In the middle.
Two motions filed by defendants. A motion to quash
All
indictment.
right, everybody in the box, you all need to be quiet.
2 motions filed by defendant. Motion to quash indictment. And motion to modify special conditions bond.
All right. And are you asking that the defendant's motion to be heard? Is there a reason to quash the indictment?
Yes, defendant contends that the indictment that was signed by the grand jury on July 14th, 2022 does not give him fair notice.
Wait a minute. So this is, you're arguing your client's motion?
Yes, I mean, it's, yes.
Okay, all
You
right.
can certainly have it done by submission, Your Honor.
No. I just want to know. All right, the court is calling 2000.
Excuse me, Your Honor, and also count number 2 with retaliation. You didn't mention that, and that was a case that was already dropped. That was the case that was already dismissed. They put the same paragraph count 2 for retaliation. That was already dismissed already.
Okay, all right.
That's pretty much like they just targeted me.
Okay, all right, Ms. Ferguson, can we send this down to impact court?
Yes, ma'am.
All right, what day?
It would be the,
And that is?
December 5th.
All right, so you're going to be sent to impact court on December 5th for jury trial.
That's fair. What day, Your Honor?
December 5th,
We can have pre-trial motions heard.
down there, yes.
Right.
All right, thank you.
I understand.
Impact court earlier this week, and it really works.
So by the way, Your Honor, can I also request a civil rights attorney too?
No, that's not what is done here. You'll need to, you can actually Google the state bar and they will give you a civil rights attorney or.
Yes, since we do this trial, we probably been a lot of improper procedures going on from the time of my arrest in my indictment in this courtroom. So they definitely put that on record too, if they off record. If they're saying I'm saying it's gonna be with me and or against me. So,
All right, so we'll see you on December 5th. Thank you, Mr. Kilpatrick. Mr. Kilpatrick, you need to get your reset form. And you need to calm down. You are in a courtroom.
Yeah, I'm kind of upset.
Well, here's the thing, Mr. Kilpatrick. I'm sure a lot of people are upset. Can you tell if I'm upset or not? No, but I could be upset right now. But you know why I'm being calm? And I need you to be calm. I hear you. I understand what you're saying. We're going to take care of your case as quickly as possible. So that is why your case is being reset for December 5th. What's going to happen is you're going to sign the reset form and you're going to meet your attorney in impact court.
No, I want to ask you something important.
Yes.
I went down to victims impact court, we was there like back in September. I'm understanding how come you have to do anything on there.
All right. Well, because that's the day that I have impact court, so it helps me to be able to have 2 trials at once potentially. So, Mr. Do you have the reset form to give to Mr. Kilpatrick? All right, Mr. Kilpatrick, if you could sign the reset form. And Norman, let them know that he's to go.
So I heard the way I couldn't get the civil rights attorneys so that I can get assistance throughout my trial.
Oh, just call the state bar, or either you can Google, and I'm sure there are plenty. I think there's still the legal aid, and they'll be able to help you. The attorneys that are signing this court are attorneys to help you with your criminal case. They're not attorneys that are assigned to help you with civil matters.
Yeah, this doesn't have to do with my civil rights throughout this whole trial. So
Okay.
This is linked to civil rights. My trial, from the time I arrest, I'm in the trial, it's part of civil rights too.
All right.
The civil rights attorney too, because we ain't no good.
All right. Thank you, Mr. Kilpatrick. Have a nice day. Charles.
Here comes another soft warning. When a defendant starts giving long emotional speeches, judges redirect fast, because anything said in open court can be used later.
State your name for the record.
Dr. Carroll,
All right. Why didn't you show up for court?
because I have problems.
We all have problems, but you're not telling me what your problems were.
Well, first of all, my daughter had her baby, but I came up with I was sick too, so my corona.
Everybody used coronavirus as an excuse, but did you provide any medical documentation that you had that?
Yeah, I do. I have that.
No. Did you provide any medical documentation to the court that you were ill?
I think I did. I should have. Do you have any?
I do not. Not for the date you're addressing, Judge.
Yes. So you did not, because if you would have, I would have that, and I don't have it.
So you don't have any paperwork at all?
I don't have anything to show that you were ill, and that's the reason why you didn't show up for your sentencing. I do have that I was lenient with you to allow you to get your affairs in order and to come back on a different date for sentencing. That's what I have. So why shouldn't I sentence you to beyond the 2 years? Because that's your agreement. Your agreement is if you don't show up for sentencing, you are subject to the full range of punishment. So my question to you is, why shouldn't I sentence you to 20 years?
Say that again, please.
Your agreement was that if you did not show up for your sentencing date, that your range of punishment would be up to 20 years in prison. You did not show up. So the question is, why shouldn't I send you to prison for 20 years?
I most definitely didn't understand that one.
No, you did, because it's a part of your plea bargaining agreement. And what I can tell you, and I'm sure your counsel will tell you this, and even though this is a new prosecutor to this court, I go over the plea bargaining agreement in great detail and ask on the record, do you understand that to be the plea bargaining agreement? And usually, well, not usually, every time I ask the defendant first, do you understand that to be the plea bargaining agreement? And they will say yes. Then I will either ask the state of the defense attorney, is that the plea bargaining agreement? And I can tell you that you were aware that you were subject to the entire range of punishment. So we're back to this. Why shouldn't I sentence you to 20 years? Because that was your bargain, that if you didn't show up for court, that you will be subject to the full range of punishment. And I remember all of the people who say, give me some extra time and I will show up.
What was going on with your daughter?
Yeah, I mean, she had a baby next month or whatever, you know what I mean? But I don't think.
What do you mean she has her baby next month? You told me she already had the baby.
No. She went to the hospital. She was sick. I thought that she wasn't gonna even, that she was gonna lose the baby or whatever, you know what I mean?
And when did this happen?
Like last month.
All right, so that happened last month. So that would have been January. So that still doesn't explain why you didn't show up for your sentencing on November. You were set for sentencing on November 3rd. Here's the thing. Sometimes people don't have an excuse. Sometimes it's like, I made a bad decision. I was enjoying my free life out here and I just didn't show up. So I'm trying to figure out, is that your case or is there something else that was going on in your life? Because you're looking at 20 years in prison.
That he doesn't have an excuse that we want to offer at this time. He does. I mean, I agree with the court. You did admonish him. He understood that. I'm concerned. I mean, as we stand here today, he's not near as cognizant of I've dealt with as he's been in the past. I'm somewhat concerned about that, but I mean, he's not a man of means. When that November date came, his phone was cut off. We were not able to locate him. I mean, he didn't. I mean, I know I spoke to him after that when his daughter was sick, but we'd ask you not to sentence him to 20 years. We don't think that's, we hope that that's not what the court decides to do, but if the court decides, we ask the court to follow the plea bargain and perhaps give him 3 years to, have been indicated that the court takes this seriously. And
all right, state.
In lieu of the explanation, the judge, the state, with previous negotiations that we have in our file, we believe the appropriate sentence would be 5 years.
All right, this is what the court is going to do. The court will sentence you to 4 years in the prison, give you credit for any time served, take in consideration 2021 CR 2207, 2021 CR 1465, 2021 CR 2771. The court will give you credit for any time served. There's a $500 fine. Time and money will run concurrent. I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
That's your signature.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand? We can go off the record. Mr. Carroll, I always, when attorneys say, can you give my client some extra time to report? Sometimes I do, sometimes I don't. But I take it very seriously when I give someone time to report, because when you think about it, somebody's saying, all right, I'm going to show up and I'm going to take my prison sentence. You didn't show up. And that's a problem. And if there would have been a good explanation, things may have turned out differently.
I don't even remember him.
All right, so you can have him have a seat. They're supposed to impact. There's not?
No,
All right, thank you.
Judge, sorry, we're just going to go ahead and surpass that because.
All right. You review that with your attorney. Did you understand it?
I believe you got it last time, yes, ma'am.
Well, no, my question is, did you review it with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
All right. Are you the same Moses Ross who was placed on deferred adjudication in 2023
Yes.
CR 3543 for the offense of assault, bodily injury, married, family on August 24th, 2023 for a period of 1 year? Is that you?
Yes, ma'am.
All right. State.
Your Honor. On or about the 27th day of September 2023, in Bexar County, Texas, the defendant, Moses Ross, did then and there fail to register for and attend battering intervention and prevention program with an approved agency in violation of condition number 18.
How do you plead to that? True or not true?
True.
State,
Your Honor, the state waives and amends the other conditions.
any objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 18, the court could find it true, grant the motion, find you guilty, sentence you to 1 year in the Bexar County Jail and up to a $4,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation 18?
Yes, ma'am.
Court will find violation of 18 true. Is there a proposed agreement?
Yes, Your Honor. The proposal, when in conferring with counsel, Your Honor, would be to revoke and adjudicate via a judgment satisfied in an affirmative finding of family violence, Your Honor.
And how much time are you all requesting?
It would be, there's 13 days served, Your Honor. The underlying probation is for a Class A misdemeanor. And so the state confirmed that, yeah, there's 13 days credit. And that was the proposed agreement, if you will, between state and defense.
Correct, Judge.
All right, so here's my question. What has he done on probation? It appears that the main thing that needs to be done when you're on for assault is the BIPP course. So has that been completed?
No, ma'am, but I could tell you what happened.
Sure, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth, that nothing but the truth so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Moses Ross. When I got put on probation, I went back to jail, and that was the time that I was supposed to sign up for my bibs. During the time
Wait a minute, that was supposed to be the time you
that
did.
was the time that I was supposed to sign up for my bibs course.
Mhm.
But I was in jail, and then when I got back out of jail, I got put on a monitor, on the ankle monitor. She's very difficult. I made an appointment to go. She approved it. I went, and they said to bibs. They said that I needed my court paperwork and $25, which I was unaware of. So I didn't get to sign up that day. Before, you know, I told you last time I said, well, can I fix what I've done wrong? And you said, you do whatever you want.
Yes.
When I made an appointment last week, and I sent her all the proof and the appointment stuff. And she says, well, you're not telling me soon enough. So what don't you understand about you having to tell me if I could go or not? And bib classes pushed back a week or 2 weeks every time. So they had someone that dropped out. I got that appointment. I went to my PO, my probation officer, excuse me, and I got my paperwork for court, and I had the $25. I make 25 each time. I made my appointment. I sent her the information, and she didn't let me go to the course. I've tried several times to go to the course, and there's nothing that I'm not like avoiding the course because of anything. It's just the monitor really, it messes with my school. I'm still in school. I quit my job because my manager didn't want to continue to print on my schedule every week for my officer, the officer.
Okay, well, what I can tell you is I'm not the person who placed you on probation. Somebody else did. I don't think that revoking him, he's only been on probation since August. So that's September, October, November, 3 months probation on an assault case. I'm not going to give him a judgment satisfied for that. I want him to complete the bib course. After he completes the bib course, if people want to come back to me and see if I would consider early termination, then of course I would consider that. Okay. But for me, the main thing on an assault family violence case is you complete the bib course. And there are consequences to a revocation and a guilty plea on an entering of guilt in the judgment from the court on these assault cases.
I agree with everything you're saying. My question is this: would you consider? So he's a professional barber. Mm-hmm. Would you consider, so that he can do his bit, get a job, get employed, pay probation? Would you consider removing his monitor so that he can resume working, going to school, and doing it?
I would consider tracking, but I will not consider removing the monitor unless somebody tells me the complainant is aware that the monitor is being removed and the complainant feels safe with the monitor being removed. And the reason why, you can unfold your hands. All right. People always would tell me in class that when you fold your hands, that means that you're upset, or it means that you're closing yourself to information that's being delivered.
That's funny.
And
No.
sometimes I do this and I'm like, I'm not closed off. But my professor would always say, that means you're closed off. So you're supposed to be
Open your
open
arms.
to receiving.
Receive it.
Yes. So people will always say that when you're a judge, you're not supposed to express yourself on the record, because if you do, and you were a judge, so you know, they say as little as possible. But I'm a firm believer that communication is key. And I don't like for people to think that I'm just doing something because I can. So the reason why I'm looking at tracking is because, one, I don't have any information from the complainant saying that they're not in fear. I don't have any information from the complainant saying that the complainant is aware of what's going on here today. And even if I were to give you a judgment satisfied, that's another concern, because part of my duties as a judge, when it's in my purview, even that's okay. Even when I'm setting bond conditions, I got to make sure that the public is protected, right? So, and let me get some update from probation. All right. And they say, she's telling me that there's an issue, the monitor, it's pretrial service issue. Norma, can you get the pretrial services officer to zoom in?
Do you lose your pretrial service?
Is the issue?
No, we're trying to find out what the issue is. See, we're trying to get everybody on the same page to communicate. So who is the person you report to with the monitor? What's her name?
Parvo, Miss Parvo, CHA, Shay, Parvo. I have it on my emails.
Yes. If you will give that to the court coordinator, and we'll get them to zoom in, and that way everybody will be on the same page.
Even
just
tracking would be amazing too.
No. Just give the information to the court coordinator.
You can call the person.
And so if you all will just wait, and we will take that up, and that way communication is.
What are the exact rules for tracking? And
tracking, you just don't have contact with the complainant.
So there's no.
And they know where you are at all times.
Yeah. So just keep it charged and go about my day. Just
Yes.
don't go to her
Yes.
place. I can't even use you.
Judge, if you would like to override that, if you would like for him to travel throughout the state of Texas, that's not really a restriction. You can also order that as well. But within pretrial, it is so he can't go past the 75-mile radius without a full order.
All right. There's no reason for you to go beyond 75 miles.
No, ma'am. No, I'm not. No, I'm not.
No, he'll be within the 75-mile radius.
That's all that we have for tracking.
Is there anything else? Any other is in effect today?
Thank you.
All right. Is there anything else?
Nothing from the state, Your Honor.
All right. Pretrial, is there anything else that you need from him?
No, Judge.
There's no curfew, nothing like that. Like I don't want to get in trouble. I hate getting in trouble. I don't get in trouble.
There's an order to things. Any other questions from the pretrial service officer?
No.
No, Judge.
No, Your Honor.
All right. Thank you so much for zooming in or trying to zoom in. And thank you so much for being by phone. No, I appreciate it. Thank you so much.
Thank you.
All right. You too. Bye-bye. All right. So this is what the court is going to do. Court is going to deny the motion, alter and amend conditions to include GPS tracking only. And when can he start the BIPP course? Do we know?
I have to do it. Right when I get out of here, I call them. I make an appointment with them. If they have any fallouts today, I could get it today. But usually they're about 4 days out, so it's not that far. So by next week, hopefully, I don't want to put it too close, but it's a holiday. Every time I've been calling lately, it's been about.
Okay, here's the thing: you're talking very fast. The court reporter, you're making her job more difficult than it needs to be. All right. So probation, he needs to be enrolled.
Generally, Your Honor, we say within 10 days of whatever ruling of the court that the enrollment happens. So can we just give him a 10-day
Yes.
threshold?
And
And I just want to confirm GPS, alternate amending those conditions are bond conditions, not conditions of.
Yes. All right. So you're to enroll in BIP no later than December 18th.
Yes, ma'am.
That's giving you more than 10 days.
Yes, ma'am.
Do you understand?